Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 109 of the NCDWI Guide podcast. On today's episode, we are looking at public vehicular areas, PVAs. Exciting content for the episode today, but before you skip on to the next podcast, because I think PVAs are something sometimes we just write off as not being important on a DWI case, I encourage you to take a listen, because I think this issue comes up a lot more than we might initially think, but also it's something that has to be argued the right way in order to give you the best chance of winning on a private drive or non-PVA issue when it comes to presenting this in front of a judge or in front of a jury. There is a lot of strategic thought that goes into correctly trying to argue a PVA issue. So before I dive in to today's episode, I just kind of want to give you a list of resources. I'm going to go through these rather quickly. You can repeat this and write them down as you need. But the first place to look at in terms of any time a PVA issue comes up is at the definitions section of chapter 20. So look at NCGS 20-4.01. That is the definition section. And number 30 under 4.01 defines private road or driveway. And then number 32 defines public vehicular area. So look at those two definitions. Then in terms of case law, look at State versus Snyder. That is 468 Southeastern 2nd, 221, 1996 case. State versus Mark, 154 NC App 341, 2002 case. State versus Leslie, 29 NC App 169, 1976 case. State versus Bowen, 67 NC App 512, 1984 case. And finally, the case that we're going to spend a little bit of time on today, and the one that is the most recent of these, State versus Ricks, 764 Southeastern 2nd, 692, which is a 2014 case. And that's the case that we're going to spend the most time looking at today. So before we get any further in, let's just go back and do a very kind of brief walkthrough of what is the state required to prove when it comes to driving while impaired cases. Well, under 20-138.1A, the offense of impaired driving, a person commits the offense of impaired driving if he drives any vehicle upon any highway, any street, or any public vehicular area within the state while either A, he's under the influence of an impairing substance, B, has an alcohol concentration 0.08 or greater. And obviously that I'm not reading that full section, so read that. And then finally, number 3, has a Schedule I controlled substance in blood or urine. So relevant portion for our discussion today is drives any vehicle, here we go, upon any highway, any street, or any public vehicular area within this state. So in order to prove driving while impaired, the state has to show the person is driving a vehicle upon a highway, street, or PVA while impaired, right? So in terms of that highway, street, or PVA, that is as much an essential element of driving while impaired as showing that somebody is impaired, right? I think a lot of our view of these kind of cases primarily comes down to, can the state show that my client was impaired? Maybe secondarily, can they show that my client was driving? But we don't often have to argue or look at or think about public vehicular area. But that is as much an essential element to the charge of driving while impaired as impairment, as driving, certainly, a vehicle. That is as essential an element. If that element is missing, it doesn't matter that you've shown that somebody was driving a vehicle and that they were impaired. Where they were driving the vehicle is as important as those other elements. And what does the state have to do with regards to each and every element of the offense? Prove it beyond a reasonable doubt, right? Proof beyond a reasonable doubt, as our pattern jury instructions in North Carolina say, is proof that fully satisfies or entirely convinces you of the defendant's guilt. That's the level. And when you walk into the courtroom, the state is the sole party that has the burden of proving each element. They're the ones that have to show this was on a PVA. It's not just a checkbox. It's not a defense to the charge that you were driving on private property. It's not a defense to the charge that you are not on a street or highway, although it will result in a not guilty, is not a defense. It's the state's burden of proof beyond a reasonable doubt to show that this occurred on a street, highway, or a PVA. It's their burden. So the presumption is that it wasn't those things as you walk into the courtroom with your client. So don't fail to remind the court of that. And certainly if you're in front of a jury, don't lose that opportunity. If you have a PVA issue in front of a jury, you need to argue like mad about the burden of proof that the state is required to show with regards to PVA, that they're the sole owners of that burden, that if there is a reasonable doubt, doubt that comes out of either some or all of the evidence that creates concern about the state having met its burden, that has to result in a verdict of not guilty. Even if you're completely sold that my client was impaired, completely sold that he was driving a vehicle, this is as important. Where the state has shown the driving to have occurred is as important as anything else. So it has to be shown that there was driving on a actual road, street, or highway. Has to show that. So that's what has to be shown on these type of cases. I've won a couple of cases where PVA was the issue, and it's something that you have to, again, try as much as possible to dig out during the consultation, but then really start to think, how are you going to present this to the jury? So again, state has the burden of proving this. So let's take a look real quick at the definition section. So first of all, under 20-4.01, number 13, the definition of highway, the term highway and street are synonymous, says that definition. Highway is the entire width between property of right-of-way lines of every way or place of whatever nature, when any part thereof is open to the use of the public as a matter of right for the purposes of vehicular traffic. So we're not going to spend too much time today looking at highway or street. But again, if you have a question about whether or not the state has shown beyond a reasonable doubt this happened on either a highway or a street, make sure you're looking at that definition section, because it could be relevant in arguing that this did not occur upon a street or highway. Number 30. This is something that is, I think, really important and should be argued. You should maybe try to get this in as a jury instruction. or part of a jury instruction in superior court. But number 30 under the definition section, so 20-4.01, number 30, private road or driveway. So private road or driveway is defined as every road or driveway not open to the use of the public as a matter of right for the purpose of vehicular traffic. Every road or driveway not open to the use of the public as a matter of right for the purpose of vehicular traffic. That definition can be really powerful if you can get that into the jury instructions that the judge reads and gives to the jury. If you can define that, if you can get them to buy into the or get them to examine, was this a private road? If there is evidence presented during the trial that this did occur on private property, that this did occur on a private driveway, that is something that you should ask for that specific language to get read to the jury, because that in and of itself helps define what a PVA is not. So make sure to look at that. Finally, most important definition for our conversation today, and just as a step back here, 20-4.01 has some really important definitions in it. If you have never read the definition section of chapter 20 and you do a lot of traffic or DWI defense, go read it. At least be familiar with what definitions there are out there, because these definitions can be very powerful for a lot of traffic cases. But under 20-4.01, number 32, public vehicular area. So what is a PVA? The definition says an area within the state of North Carolina that meets one or more of the following requirements. So number A is the biggest, 32A. The area is used by the public for vehicular traffic at any time, including by way of illustration and not limitation, any drive, driveway, road, roadway, street, alley, or parking lot upon the grounds and premises of any of the following. So it says any public or private hospital, college, university, school, orphanage, church, or any of the institutions, parks, or other facilities maintained and supported by the state of North Carolina. So hospital, college, university, school, orphanage, church. Number 2, any service station, drive-in theater, supermarket, store, restaurant, or office building, or any other business, residential or municipal establishment providing parking space, whether the business or establishment is open or closed. Those two definitions, 20-4.01, 32, A1 and 2, those two sections of the public vehicular area definition are going to be the most common. I would imagine that most of this is going to fall under that. So if there is a question about whether or not this happened in a PVA, most of the time, those examples, and again, the statute does say that these specific examples are being used by way of illustration, not limitation. So this is not an exclusive list. However, State versus Ricks, which we're going to talk about in a second, does say, hey, it's important that in explaining PVA, that the legislators used these specific examples. And so the fact that there is a list is important to take note of, and what's missing from that list is important to take note of. So there's kind of a contradiction between the statute, which says this is a not exclusive list, and State versus Ricks, which says, well, it pretty well spelled it out in the statute. So we don't know why there was so much description given, unless this was meant to be a pretty exclusive list. So again, a little bit of back and forth, but read that dicta from State versus Ricks in terms of the kind of detail that is in that list of definition number 32 PVA, because they really say this kind of spells it out. And so if it's not on the list, that's important to take note of. Under 32B, it says a PVA also includes an area that is a beach area used by the public for vehicular traffic. So this really only is relevant for our brothers and sisters on the coast of North Carolina. Any beaches that allow for driving on the beach, that would qualify. But it says the beach area is used by the public for vehicular traffic. So if you have beach areas that say no driving allowed, or maybe no driving after a certain time frame, and it's outside of that, if it's not allowed, then it's not a PVA. Or at least I think there's a very strong argument that it's not a PVA at that point. Number C, and this also I think you would potentially see quite a bit when arguing these. The area is a road, so this would also be a PVA. The area is a road used by vehicular traffic within or leading to a gated or non-gated subdivision or community, whether or not the subdivision or community roads have been offered for dedication to the public. So you've got a road leading into or within a community, homeowners association. And then finally, PVA definition number D, or letter D, the area is a portion of private property used by vehicular traffic and designated by the private property owner as a public vehicular area. So it can still be considered a PVA, even if it is private road or private drive, if the private owner has designated it as public. That would probably be a very difficult thing for the state to prove, without having maybe the homeowner themselves come in and testify and talk about how they had dedicated or opened this up to the public. So that's going to be a difficult one for them to prove, but just know that that exists out there as a way around that private land. So again, there's a lot of examples that are given in the definition section itself. So first of all, if you have a potential PVA issue, comb through that definition section for PVA under number 32 and see if there's anything where that kind of strictly falls within one of those items. But again, remember, this is an element that the state has to prove beyond a reasonable doubt, right? Has to prove beyond a reasonable doubt. You know, you hear so many times in a DWI trial, the state going through kind of its form checklist of questions. Trooper Jones, can you tell me where this happened? This happened on US 74, and Trooper Jones is US 74, a street or highway within Buncombe County in North Carolina. Yes, it is. Okay. So in those couple of statements, they've effectively attempted to show the court this happened on a street or highway, that the street or highway portion of the DWI elements has been satisfied. But when it comes to PVA issues, I think one of the biggest benefits to the defendant is sometimes that these things don't get fleshed out by the district attorney. Or by the officer, that there's not this kind of full explanation of where specifically this happened, that this did occur on a street or highway or PVA. And so part of the opportunity on some of these cases is how aware going into the trial is the assistant DA handling the case. How aware are they that this is a PVA issue? Because if they're not asking a lot of questions about this, it may be difficult for them to kind of pull this out. Now, if the case goes up to Superior Court, they're probably going to have a pretty good idea that this is one of the issues if that's been raised in district. But in district court, you may have a situation where there's not a lot of knowledge on the state's end that this particular element is an issue. If you just say, hey, taking the case to trial, my client wants a trial on this issue, they basically have to prove everything under the sun. Stop was good. What was the results of the field sobriety tests? What happened in terms of PBT at the roadside? How long did it take to get back to the jail? When was the person advised? All these different things, obviously, that we see in every case, but they may not be focused on where specifically the driving occurred. Where did the driving happen? That may be an issue. So let's take a look at the Ricks case, because I think this is a really, really powerful case for the defense for a few reasons. First of all, let's look at some of the facts of Ricks. So this was a moped situation, and Officer White of the Rocky Mount Police Department was the responding officer. So he finds the defendant, the moped vehicle, on a driveway. So what this is the description from the case about where this driving occurred. All that remained was a driveway cutting directly across the lot from 1 Street, South Church Street, to Bassett Street. The officer referred to the driveway as a cut through and testified to having seen people walk and ride bicycles across it. It at one point was paved again, but now was basically dirt. The officer recalled that the driveway appeared to have been paved at one time, but was now dirt. The officer explained that the foot and bicycle traffic kept the area mowed down. There were no fences or barriers preventing access to the lot or cut through. The officer testified that the cut through was wide enough to drive a motor vehicle through, explaining that he pulled his patrol car into the cut through while he was dealing with the defendant. The officer also testified that he had seen cars use the cut through to turn around, yet it was mostly used for foot and bicycle traffic. The state never found out who owned the lot. So that is the definition. Again, this is a lot. Apparently had some sort of a paved driveway through it at one point. No indication as to whether this was public or private property. It appeared to be private property. No knowledge of who owned that private property. So these are the kind of issues that the court is having to look at. And so in the Ricks case, at trial in Superior Court, this was the major issue at the trial court level. And so the judge denied the defendant's motion to dismiss at the close of the state's evidence, where the defendant argued that there was not sufficient evidence presented as to this being on a public vehicular area, denied the defendant's motion to dismiss, and then only read a portion of the PVA statute to the jury, and really wouldn't let the defense counsel in closing argue the full definition of 20-4.01 number 32 PVA. So again, not only did the judge not read fully in his instructions 20-4.01, but he was not letting the defendant, the defense counsel, in closing argue that. So there's a couple of important details that came out of this. Number one, and the most important reason for this case being so powerful, is that you have facts similar to Ricks. It's just not clear whether or not this is a PVA, private road, a road at all. If you have issues as to where the driving occurred, Ricks is a really powerful case because of the fact that it said that the trial court erred in not granting the defendant's motion to dismiss at the close of the state's evidence. At the close of the state's evidence, remember, we're looking at all the evidence in the light most favorable to the state. In the light most favorable to the state. So the facts that I just read, when looked at in the light most favorable to the state, the Court of Appeals said not enough. Defendant should have had his motion to dismiss granted at the close of the state's evidence. Okay, so before we ever get to the guilt phase, before the defense is arguing beyond a reasonable doubt, when looked at in the light most favorable to the state, this did not get it done. So that is part of the reason why Ricks is so powerful, is based on those facts. They just said, still, when looking at all that in light most favorable to the state, still not enough. So if you have facts similar to Ricks, make sure that you're not only arguing the consistencies of your factual scenario and the similarities of your factual scenario to the Ricks case, but make sure you're really pounding the burden of proof and the fact that this should have resulted in the trial court granting the defendant's motion to dismiss at the close of the state's evidence. Really pound that standard. The other thing that's important is, despite the Court of Appeals finding that the trial court erred in not granting the motion to dismiss, they said that the trial court erred also by not allowing defense counsel to argue the full statute under 20-4.0132. That it was improper for defense counsel not to be able to have the jury consider the full definition of public vehicular area. And although the court didn't touch on this, I would say certainly to argue a private road under 20-4.0130. If you have the chance to argue these things, you absolutely should be arguing the definition of a private roadway. So ultimately, the court should have found as a matter of law in Ricks that this was not enough to get to a PVA, should have granted the motion to dismiss as a matter of law. However, in a situation where the court doesn't grant that motion to dismiss, it is now the jury that gets to decide whether or not the element of PVA has been met. That is a jury question. It is a factual question. So can the judge advise the jury about what a PVA is? Can the judge try to give instructions that help the jury to understand the difference between private drive and PVA, explain what constitutes a PVA? Yes, the judge can explain about that, but it's still the jury that gets to decide the PVA element being met beyond a reasonable doubt. So you have to be prepared then to argue that element to the jury if that element is in issue. You have to be prepared to argue the case law on that to the jury. You have to be prepared to argue the statutory definition section. There's no way for the jury as a matter of law to be told you have to find that this was a PVA. It's a jury question. And so what your argument is, hey, jurors, members of the jury, if you're not fully satisfied or entirely convinced that this patch of grass near the roadway or that this particular section of alley was a PVA, you must return a verdict of not guilty. And you have to be able to explain what a PVA is, what a private drive is. You have to talk through that. It's not something that should be assumed. The state has to prove that beyond a reasonable doubt. So make sure that in a relevant situation in front of a jury, if there is indications that this happened on a private drive, private property, private roadway, then ask for 20-4.01 number 30, which is the private drive definition. Ask for that to be instructed to the jury, for private road, private drive to be read into the jury instructions so that the jurors can hear what the difference is, what the opposite side of things is. Even if it's not on a private drive, it still may not be a PVA. But if there is a private drive issue, make sure that the jurors are hearing what that looks like so that they can decide whether or not beyond a reasonable doubt that element of driving while impaired is satisfied. The other thing, and again, so this now we're gonna kind of talk about how this plays out practically. Again, the state may not be unawares in district court that this element is an issue. They may not be prepared to ask a lot of questions about this. The officer may not have a lot of memory or knowledge about where exactly this happened. So this is one of those places where doing some digging and site investigation can be very helpful. If you've got a situation where PVA might be an issue, your argument's going to be this didn't happen. The state hasn't proved this happened on street, highway, or PVA. It's helpful to try to get some of your own investigation done on that front. So, number of easy ways to do this. You can look up on MapQuest a billion different places, the pinpoint where this happened. Google Maps has Street View, right? So you can have like the street view of where this happened. Go out to the site and take pictures, right? If you go out and take pictures and then you're able to cross-examine the officer as to where exactly this happened on those pictures, and you know that that's going to make it more likely that PVA is in question, get that visual evidence in front of the judge or in front of the jury. Because from the state side of things, this is a checkbox. This is an easy element to be made. Was that parking lot, Officer Jones, a PVA? Yes. That's it, right? There's no kind of like map or looking at it and deciding, hey, did you take pictures to prove this? It's just testimony based. I don't think that I've ever seen the state on its own until this was raised on my end, get too excited about proving PVA other than to ask the officer, was this a PVA? And the officer is going to say, yeah, it was a PVA. And that's the end of the analysis. So don't lose that opportunity to make sure that if there is some helpful visual evidence to present on the case, that you are able to present that visual evidence. Pictures, Google Maps, MapQuest, whatever it might be, there are a number of different ways that you can try to show through cross-examination or putting your own witness on the stand evidence about this being a PVA. Don't miss the opportunity to hold the state's feet to the fire if they don't know who this is. I mean, if you're charged in a McDonald's parking lot, then yes, maybe it's pretty easy to just say, yeah, this was a business, it was open 24 hours a day, having in one of the parking spaces. That might be hard to have any type of a dispute or question about. But if you don't have a clear owner of the property, owner of the land, we don't know if this is private, public. We don't know anything about the specific business, if this is for employees or open to the public. A lot of times the officers, particularly where there's just basically, a parking lot where the person is found, they don't get a lot of information about the details of the business where this vehicle was found. And again, it's their burden of proof beyond a reasonable doubt to prove that that PVA element has been satisfied. So don't let them, don't let that slide. Don't let them just be able to kind of push that through. It's their burden to meet that. So again, just to quickly recap, make sure you take a look at that definition section for PVA. Read the cases that are around this. Make sure that you're arguing that this is an element of the offense as much as impairment is an element. It has to be proved beyond a reasonable doubt. In regards to the Ricks case, if you have facts similar to that scenario, make sure that you tell the court this was a situation based on the facts of Ricks where it shouldn't have even got to a jury. Even when looking at the case in the light most favorable to the state, the defendant's motion to dismiss should have been granted, and then go out and do your own side investigation. If there's helpful information to contest whether or not this was a PVA, or to put into question whether or not this was a PVA, do that. Again, we are not assuming the burden of proof on this element. So you're not required to go out and take pictures in order to prove this occurred on private property, or in order to prove that this didn't happen on a PVA. You're taking those pictures to cast reasonable doubt on whether or not this happened on a PVA. Sometimes that doubt might be very strong, almost a defense in and of itself. But at the end of the day, make sure you're presenting it as, judge, this is their burden of proof beyond a reasonable doubt. Based on all the evidence that has come out, they have not met that burden. So make sure that you're arguing that the state has the burden of proof, carrying this just as much as they would have with impairment. Hope this information has been helpful, and I look forward to speaking with you next time. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.